Hi guys, it's Kathy. I hope you're doing well. We're going to spend the day together in California. Nope, Colorado. Colorado. We're going to spend the day in Colorado. And I think I'm moving to Colorado because this guy is saying that his doctor prescribes alcohol as a prescription. I want that. I want a doctor who says that. Is that true? All right, it's just tiny amounts of alcohol that he says. And I'm sure that he's lying. But is that true? Can I know cough medicines have some alcohol in it. They're not prescription. Can doctors prescribe alcohol? What does alcohol cure other than everything? Besides everything. I can't get what Dr. Booze. Dr. Feel Good. All right. We're going to Colorado. And I made a mistake, but it's a mistake that only you guys will enjoy, apparently. So, yesterday I put out a video. There was this jerk in 2023 that when he was arrested, there was no paperwork. The court didn't have any paperwork. So they released him. They had to, right? And he was a real jerk. And, he told the judge how he owns her now. That whole part is 5 minutes long. Well, I went into that guy's records and I looked to see, this was back in 2023. So I thought maybe there was an actual paperwork that, just followed up later. There was. He got released, but then they charged him with domestic violence. And I looked at all of his cases and he has escalated since then. Picked up a couple felonies, bringing controlled substances into the prison and theft and more domestic violence and things like that. He was a real jerk, so it was really satisfying. He also had mental issues, so they sent him to the state hospital for a while. And then he was going to serve his prison time. Now his sentence is it's on the 28th. So in 14 days, he's going to get sentenced again. I don't know how long he's going to go to jail. I think there's like 6 or 7 counts of theft and bringing controlled substances into the prison. Anyway, listen, he got that judge dismissed. Not the judge that released him, but the judge that they finally got the charges brought up against him in front of. He got that judge dismissed. So what I did was I made this video and I released it. And the first 5 minutes of him acting crazy in court and swearing and da da da, people, it was great. But the last 5 minutes of me going into his cases to show you all of his charges and things that are coming up, people hated. But not you guys. You guys love when we give you the cases of the people who are, in front of us. But in videos, I guess people don't want any extras in videos. So I've decided that I'm only going to share those tidbits with you guys from now on in my live stream, because you guys are like, oh, look at all those cases. People watching the videos like, no, I don't want to know that. All right. This is who we're watching, and this is his attorney. Here we go.
Jones.
Yeah, so Mr. Batts had advised me this morning that he does want to set for trial. However, at this point, I don't think that's a good idea. I do intend to file competency motions tomorrow to put a hold on this case as of right now, just based on my interactions that I had with him this morning.
Okay. Well, I mean, I understand that. I guess I'm a little confused as to why we didn't address the competency issue earlier, Ms. Jones, since the district court attorney had already filed it a couple weeks ago.
Yeah, and the reason that I didn't do that, and I don't want to go too far into my
Sure.
interactions with him, but I have had no interactions that even gave me any indication that there could be a competency issue. I think that it's possible that Ms. Atkinson maybe spoke to him during different times in the day, and that led to her conclusions. But the first time that gave me concern was this morning when I interacted with him. So
Okay.
I do intend to file a competency motion based on that.
So it's very convenient after I filed a complaint against your ability as an attorney for you to make that
Well,
lodge.
yeah, I
Make
mean,
that out.
yeah,
In case you didn't hear him, he said it's very convenient after I filed a complaint against you as an attorney for you to file that competency issue against me.
here's where things stand, Mr. Batts, sorry. When the issue of competency is raised, what happens is there's a stay in the proceedings. And so any sort of deadlines that exist in the case are, they don't run during the time period while the court addresses the competency issue. And so while I anticipated we were likely going to be setting for trial today, it doesn't really make sense to set it today because the competency motion is going to be filed and the proceedings are going to be stayed while we address that competency issue. And so what the court is going to do is set this for status in the near future so that we can address the competency issue. How long do you think you'd take to file the competency motion, Ms. Jones?
I anticipate that I can file it this afternoon.
Okay. You can also file the motion as one to receive the competency evaluation in the felony cases if you'd like. That way we don't have to do duplicative interviews and things like that. What I'll do is I'll bring this back then for status in 3 weeks. My hope is that maybe the competency issue has been resolved because it was raised earlier in July on the felony cases. And then that way, when you come back in September, Mr. Batts, we can make some progress and figure out what we need to do on the case. And so what I'd like to do is bring you back to court on September the 3rd at 1:00 p.m. That way we can, if we're going to enter a not guilty plea, we can do it that date. And we can hopefully figure out what direction things are going. And so is that available for the prosecution?
Yes, Your Honor.
Okay. So Mr. Batts, we'll see you back in a couple weeks and we'll go from there. All right. Thank you.
Hi, Anna Banana.
I'm ready on Mr. D.
I don't know if we're going to see him in Blanco's courtroom or not, even though he just had competency raised. So usually we see him there. But this is Mesa County. I don't know if she does Mesa County. I'm trying to remember anybody that was ever in front of her from Mesa County, and I can't. So now I have to figure out where he's going. I know there's an Judge Arnold I need to find that also does mental health court. But I don't know if it's a guy or a girl, and I don't know where they're at. Also, like, Blanco doesn't do competency every single Thursday. So I'm going to try to get the mental health court later today. But I don't think she's going to stream today. Hopefully, we'll see.
Daniel.
All right. Let's call Mr. Daniels. This is 24T820, 24CR923, and 25T1579. We've got Mr. Daniels present with Ms. Jones. We've got Mr. Collinsworth with the prosecution. We're scheduled here today for status. Ms. Jones?
Mr. Daniels would like to address bond today. I was able to put the DA on notice this morning, so if he's prepared to address it, we would like to move forward today.
All right, Mr. Collinsworth?
That's fine, Judge.
Okay, let's address the issue of bond.
Okay, so we're addressing the bond in 24 CR 923. There's a cash-only bond. We're asking the court to modify it to a PR bond, or in the alternative, a cash or surety bond that Mr. Daniels could post. I know that the court is likely concerned about Mr. Daniels' FTA history and the fact that he was kind of MIA for quite some time. I do think that based on my conversations with him, his circumstances have changed a little bit that have caused him to reprioritize resolving his cases. He recently started a job doing commercial and residential painting. That's the first job that he's held consistently over the past several years, and he is very proud of that job and does want to continue doing that whenever he is out of custody. He's also recently got a phone. He hasn't had a phone or a way that I can contact him for a year. He's been able to get that after he started this job. He's also advised that his mother is on oxygen. She does have difficulty moving around the house. At this point in time, she doesn't have anyone that's able to help her run errands or do anything like that. He is the only person that she can rely on at this point, and he wants to be home to be able to help her with that. He's also living with her, so he does have a place to stay. He does have a way to court. He's advised that his uncle can take him to court or he can take the bus. It does look like after he was released, he did miss that court date on August 4th. We had a conversation about that. He said that his ride didn't show up, and at that point, he didn't see that there was a point in trying to come to court or report to probation. I told him that that wasn't a good idea. We had a conversation on how to move forward if something like that happens again, but he does understand the importance of communicating with me and staying in touch and showing up to court. So we're hoping that given his circumstances right now, he's going to prioritize these cases moving forward and continue to show up. So we're asking for a PR bond.
All right, let me go over to the prosecution. Mr. Collinsworth?
Thank you, Your Honor. So clearly people are concerned about his ability to appear for court with his failure to appear history, in addition to his compliance with probation. So it's not only his FTA history necessarily from court, it's also he's not been complying with probation either. Because of this history, I'm going to oppose modifying bond in this case. I'll defer to the court, but I just don't think that we have had any showing that he is able to or willing to comply with either probation or showing up for court based on this history. So I'd ask the court to keep bond as said.
All right, thank you, Mr. Collinsworth. Well, this probably isn't a surprise to Mr. Daniels, but I'm not willing to modify the bond. You know, the way that things have been going in this case is that Mr. Daniels hasn't been reporting or checking in with probation or doing what he's supposed to do regarding probation. His probation officer was present back when we talked about this issue in February of 2025. Shortly thereafter, Mr. Daniels absconded again, and he went off the radar. He stopped showing up on these cases. He certainly hasn't been checking in with probation, or he would have been remanded and taken into custody earlier. And so that's not happening. In his cases, he's missed court a substantial number of times. When I looked earlier in 24 CR 923, I think he's missed court 6 times on that case. Or maybe that was in the other one. Maybe that was in 24 T 820. Yeah, it was in that case that he's missed court 6 different times.
It's never good when the judge remembers you from all your other cases.
And so there's no confidence that the court has that Mr. Daniels will show up. Quite frankly, these cases have been pending for a year. There's no reason why they should be pending this long, other than the fact that Mr. Daniels has not been showing up to court. In fact, when we were back in court in March of 2025, there's information that there was a disposition that the parties had reached, but we still don't evidently have one here today. And so the court declines to modify the bonds in these cases. And so, Ms. Jones, how would you like to proceed?
I would just ask for a 3-week set over. Mr. Collinsworth has advised that he should have an offer out soon.
Well, there was an offer out beforehand.
There was a
that Mr.
disposition, but he's since picked up new cases, and those aren't included in that disposition.
Okay. Well, I mean, I can set it over 3 weeks. I'm hoping to have resolution on that date, though, then. Why don't we try to come back on Wednesday, September the 3rd at 1? Would that work for you, Ms. Jones?
That works for me.
And then would that work for you, Mr. Collinsworth?
It would, Judge. And with the trials being vacated tomorrow, I intend on having an offer sent out tomorrow on these cases. So we should have movement pretty soon.
Perfect. I mean, I think the new case is not particularly complicated from what I could see. It's just a no proof of insurance. And so that was why I'd been hoping maybe there would be a resolution
There's also
today.
a possession case. I think he was also charged with a DM1 too. I don't think the traffic case is the only one. But I agree. I do think that it's possible to have a resolution in 3 weeks.
Wait, is there a DM1 case that I don't have on my docket? Is there maybe another new case I didn't call?
Maybe. 1 second.
Because I didn't see that when I was looking earlier. Let me just pull that up.
I think it's 25N 2145.
Oh, okay. I didn't see that. Let's go ahead and call that case. So the court's going to go ahead and call 25M 2145. That case, if it's not already assigned to Division 1, is hereby assigned to Division 1. That court date in October is vacated, and it'll return with the other cases on September 3rd at 1:00 p.m. That makes sense. I didn't see that there was that case as well, and so I completely understand now how it complicates things for purposes of a disposition. So, Mr. Dinos, we'll see you back in 3 weeks, and we'll go from there. Okay?
Can we call John Smith?
Yeah, let's go ahead and call Mr. Smith. And so go ahead, Mr. Smith, come on over. This is 23M1405, 24M2212, 24M5182, and 25M430. We've got Mr. Smith present with counsel Ms. Jones. We've got Mr. Williams with the prosecution. We're scheduled here today for status. Ms. Jones?
Judge, we're asking for a set over in this case. We're still waiting on an offer for a resolution. We don't have a global offer, but it's been my understanding that that's how these things are going to resolve. He does have some ongoing medical issues that he's been dealing with upstairs. He's been able to get a furlough for some of those issues, but it's kind of put his felony cases upstairs on hold, which is why these cases are moving along fairly slowly.
All right. Well, the court will point out, for example, 24M2212 has been pending since July of 2024. And so we're now past a year into the case. Is there a global offer that's been extended that involves these cases?
Your most recent one, though?
Okay.
There
Well,
has been no misdemeanor offer extended to me. If there was a global offer, I was not included in an email chain, but Mr. Smith is indicating that there was a global offer.
okay. Well, so I think we probably all need to follow up on this issue because next court date.
How mad is she right now? On a scale of 1 to 10, how mad is she? I would be super pissed off if they did a global offer and didn't even tell me what they're doing with my client.
What I am going to do is I'm going to set Mr. Smith's cases for trial in light of how long the cases have been pending. And so, if they need to be separated from a felony for purposes of negotiations, I don't have any objection to that. I don't have an objection setting them for trial. But the reason that I brought Mr. Smith here today is I can't just have these cases penned indefinitely for more than a year. And so why don't we try to come back in 3 weeks for entry of plea one way or the other on September 3rd at 1:00 p.m. Does that work for you, Ms. Jones?
Yes, Judge.
And then does that work for you as well, Mr. Williams? Okay. So we'll come back then. And Mr. Smith, I hope that everything's okay with your health right now. And I wish you the best of luck trying to address that. And so,
Yeah, what are we
Also
doing
ready
up
on
this
Mr.
early?
Krause.
all right, let's call Mr. Krause. This is
We are up this early, crazy cat, because we don't sleep. We watch court videos.
25M2135.
Steven!
Go ahead and take a seat there, Mr. Krause. And we've got Mr. Krause here with counsel Ms. Jones. We've got Mr. Rocky with the prosecution. We're scheduled here today for status. Ms. Jones.
Mr. Krause is hoping to address bond in the 25M2135 case. I did send notice this morning. It is a VRA case. So I would defer to Mr. Rocky as to whether he's ready.
I don't think it is VRA because it's just a violation of protection order, but it's one where I'd want notice to be given. But
Yeah, I wasn't able to speak with the victim. It is not a VRA case, as you said. The victim did give us some input just 3 days or 2 days ago when this bond was set. But it's possible, that position has changed. I wasn't able to get a position though. So I would like some more time to get a victim position.
why don't we set this over? My information is I potentially have tomorrow open so we can address the issue of bond tomorrow. Would that work for you, Ms. Jones? I could do Friday as well.
That tomorrow's okay.
Well, yeah, sooner the better with these health issues.
I mean, obviously I would prefer to do it today if it's not a VRA case, but if the court is inclined to set it over, we would like to set it over to tomorrow.
Yeah, I mean, in light of the nature of the charges here and the other pending charges that Mr. Krause is facing, I would like to have the opportunity for the victim to potentially provide input to the prosecution. And so I am going to set it over to tomorrow, which would be the 14th at 1:00 p.m. And we can address bond. I am going to call Mr. Krause's other cases. That's 21M2685, 25M1605, and 25M1945. Those cases will also come back with Mr. Krause tomorrow at 1:00 p.m. Yep, I'm going to get you the same court date on all of them, which is going to be tomorrow. And then we'll get a new court date from there, Mr. Kraus. That way we're going to keep all 4 of your cases together moving forward.
Oh, okay.
Yep. So I'm going to vacate the 25th date. You're going to come back on those tomorrow, the 14th. Okay?
Okay.
All right, we'll see you then.
Thank you, Judge.
I see that Ms. Swallow is with us on WebEx. Ms. Swallow, just so you know, I think that your client is potentially in treatment, and I don't see that he's present, so that's why I have not called him yet. And so I'm not sure if you can hang out a little bit longer, but that's why I have not called your case yet.
Thank you, Judge. I've also got Mr. Russo, who's in custody.
Oh, you
And
do?
then-
Oh, yeah, okay.
With respect to
call that.
Thank you, Judge. With respect to Mr. Shelton, I'm not sure if there's a way for the court to check and see if he's in the WebEx waiting room. He's indicated to me that that is where he is.
I don't see that he's in. I don't have anybody waiting in the waiting room, so he,
I really highly doubt the live stream viewers are on a schedule. Like maybe the international viewers, that's different because it's not 4:30 a.m. where you are right now. But for the live stream viewers in America, like this live stream starts at 4:30 a.m. every single day. Well, ish. So I don't know if we actually have sleep schedules. Like I go to sleep at this time and wake up. We sleep when we're tired, and then we wake up when we're done being tired. And that could be at any point of the day. I don't know what my schedule is. I just don't know. Sometimes, so it's normally right after I finish finding content for tomorrow's live stream. So sometimes I can get 8 hours, sometimes I can get 2 hours, sometimes I get no hours. I don't know if we have a schedule. We just fall asleep when we're tired. And then we wake up when we're not tired anymore.
might be in the wrong room.
Okay. Okay, thank
Okay.
you, Judge. Yep, we could call Mr. Russo and then pass Mr. Shelton.
All right, let's go ahead and call Mr. Russo. This is 25M1612. We've got Mr. Russo present with counsel, Ms. Swallow. We've got Mr. Williams with the prosecution. Ms. Swallow?
Judge, we were hopeful to have a resolution today. However, Mr. Russo has new case 25 CR 697. And so I've reached out to the prosecution to see if there's some sort of global that might resolve both. For that reason, we're asking to continue, ideally sometime past September 4th, which is when he's next set on that other matter.
Yeah, I could bring this back on Wednesday, September the 24th at 1:00 p.m. Would that work for you?
Just one moment here. Yep, that works for us.
Does that work for the prosecution?
It does, Your Honor.
Okay. Then, Mr. Russo, we'll see you back in 6 weeks from now on this case. Yep. All right,
Thank
thank you. And then I'll keep a lookout for Mr. Shelton. I don't see him yet, but I'll recall that as soon as I can.
Appreciate it.
All right, I see that we've got, that is Mr. Davis, right? Okay, are we ready on Mr. Davis? I don't see that Ms. Spradlin is here yet. Do you know, is she going to be present, Ms. Jones?
I will send her a message. I'm not sure that she's with us.
Okay. All right. I think we can call Mr. Meyer since he refused, right? All right, so let's go ahead and call Mr. Meyer.
Monica, thank you for the bits. Thank you.
This is 25M1971, 24M5005, People's State of Colorado versus Alfred Meyer. Mr. Meyer refused transport here today. His attorney had previously requested to bring him back on, what was the date that she'd requested? Ms. Jones, this is your case. I didn't want to interrupt you while you were talking about, maybe Mr. Meyer,
Mr. Meyer.
he
yes.
refused transport today. If you can come on up, we're just going to get a new court date. What was, are you requesting September 3rd at 1?
That's correct. Yeah, I did send an email. I think it was like 10 minutes before noon. so-
Yeah. So why don't we go ahead and if it works for the prosecution, bring him back. It'd be Mr. Rocky on September 3rd at 1:00 p.m.
That's fine.
Okay. So Mr. Meyer will return then.
Thank you, Judge.
And so I think we're just waiting for Mr. Shelton and Ms. Spradlin.
Okay, we're
Ms.
going.
Spradlin just entered, and so her,
We're gonna leave him for now. He did good. We're gonna move to a different judge. I don't know if I got a lot of this, Judge. I did. I got enough. Let's go back. We'll just hang out with this judge for a little bit. Oh wait, we might not hang out with this judge if he doesn't unmute. I can't remember if he's the one that doesn't unmute.
Arizona,
He
and
unmutes.
FTA that case. Here, she not only presented fake registration card, but she refused to get out of the vehicle when officers requested her to. She also has a pending DUI case in Boulder. The people have concerns for her non-compliance with the commands of peace officers and her behavior on the roadway, which presents a risk to public safety. We would ask for a $7,500 co-PR bond with MIPS authorized and no driving without insurance and registration.
From the defense.
Yes, Judge, we're asking for a personal recognizance bond. She's got no Arizona convictions. She has no convictions out of Boulder or anywhere else. She has no criminal history in Colorado. She has ties to Colorado. Although she was residing in Arizona, she's got family here, including cousins, an aunt who's also her godmother and the reason that she's in the area. And she was born and raised in Boulder. She has extensive work history, although she's now retired. She has someone available to co-sign if necessary, but I think that a personal recognizance bond is appropriate. I think, frankly, if the court hadn't already found probable cause and if she remains in custody, I recommended that she set for a preliminary hearing on the probable cause on the attempt to influence a public servant. I don't believe that these facts are what I have seen in 8 years of doing this work myself to support probable cause on the attempt to influence. Here they've reserved bond as she wanted to speak to an attorney prior to doing any kind of pretrial interview. But again, given the facts of the case as alleged in the affidavit and given the lack of criminal history here, a personal recognizance bond is appropriate.
So she lives in Colorado. This is Colorado. She calls it Colorado. Is it Colorado? Do people in Colorado call it Colorado and the rest of the whole world calls it Colorado? I need to know if I've been saying it wrong my entire life.
Court does note there is another pending case for DUI to Boulder County. Looks like this as well has expired registration plates as one of the charges that they're also reviewing the affidavit, taking everything in consideration, including the bond application. As was already mentioned, the court doesn't have the benefit of full bond application as Ms. Kuzma declined to participate, which is her right. Taking everything into consideration, the court's going to set bond amount of $10,000 personal recognizance. Court's going to set.
Oh God, I love that idea so much because it's not actually illegal to get drunk and FaceTime a judge. So we're not going to get in trouble. I love this idea so much. I actually have a platform where we can do it. Not here, not YouTube, Discord. We can all log into Local Vibrations on Discord and call up our favorite judge, but we all have to be drunk. Nothing could go wrong with this idea. Absolutely nothing.
That bond amount or standard pretrial services, court's going to authorize MIPS remain law-abiding. Court pretrial services within 24 hours of your release. Comply with mandatory protection order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim in actual charge of committing. No driving without a valid driver's license or insurance. Next court date will be August 19, 2025 at 8:30 a.m. and 5 a.m. Anything else from the people or defense?
Nothing.
Thank you. Deputies, who we have next?
We have De La Rosa on the mobile unit, Your Honor.
De La Rosa, 25M1916. Good afternoon. Good station name for the record.
Angela De La Rosa.
Did you watch the video or read piece of paper?
Yes, but only if it's Spanish from Spain. So the Spanish people in Spain do they have a lisp. They have like this lisp in Spain that other Spanish communities don't have. So the D in Colorado carries when the Spanish is from Spain.
Advising your rights.
Yes.
Do you have any questions regarding your rights?
No.
Okay. Have you had an opportunity to review the charges against you?
Yes.
Court did review the affidavit in support of warrantless arrest, did find probable cause. We'll start the people regarding bond and bond conditions.
The defendant's behavior with officers in this case is highly concerning to the people, especially because the officer requested a no contact order, which I don't see often. She has a high CPAT score and 5 FTAs and 3 failures to comply. So I think a higher cash bond of $500 is appropriate here. Additionally, although this charge in particular doesn't involve alcohol or drugs, the defendant was found at a bar by police and has a history of drug use. So I would be requesting monitored sobriety because I do believe that will help assure that she will not FTA her court appearances. We'd also request that MIPS be authorized.
From the defense.
Yes, Judge. First, I would say that I think that it's, again, the court's confined to the 4 corners of the affidavit. She was charged with nothing in regard to her behavior towards law enforcement or anyone else. This is a class 1 misdemeanor on unauthorized use of a motor vehicle. If the people were so concerned about her behavior towards officers, I would think that that would have warranted some sort of charge. Being that that is not charged, I think it's inappropriate to consider. As well, I'm going to ask that the court, if the court imposes standard supervised probation, that the court does not include drug or alcohol monitoring. Being found at a bar does not mean that she has any kind of drinking or alcohol problem, or that that would contribute to her non-appearance, or that it would contribute to any inability to comply with this court's orders. So I, again, think that that consideration, when it doesn't relate to any charge in the affidavit or what we're here for, is incredibly inappropriate. I'm going to ask for a co-signed personal recognizance bond. Ms. De La Rosa also has her entire immediate family here, has been in Colorado for the last 47 years, is working, and it has significant ties here. So I think that co-signed personal recognizance bond, only in light of the FTAs, would be appropriate in this case.
Thank you. Reviewing the bond application arguments from people in the defense as well as the affidavit, the court does note CPAT score of 4, overall score of 15, 5 failures to appear, 3 failures to comply. Taking everything in consideration, courts can set bond the amount of $100 cash only. Courts can order standard pretrial services. Court authorized MIPS remain law-abiding, report probation and pretrial services within 24 hours of your release. Comply with the mandatory protection order that states you shall not harass, molest, intimidate, be tied against, or tamper with any witness to or victim of the actual charge of committing. No contact with the named victim in the affidavit with a 50-yard distance restriction. Next court date will be August 25th, 2025 at 1:30 p.m. in 5D. Anything else in the people or defense?
No, Your
Yes,
Honor.
can I set up a time to get my stuff from her apartment? Because that's where I was staying at, was at.
Ms. Marchek, are you requesting a civil standby?
Yes.
Perkins, do you have objection?
No.
Okay, court will authorize a civil standby. Okay. Thank you. Deputies, who we have next?
It's Todd, Your Honor.
Okay. Todd, 25M, 1921. Good afternoon. Could you state your name for the record?
Kenyatta Todd.
Did you watch a video, read a piece of paper advising you of your rights?
Yes, sir.
Do you have any questions regarding your rights?
No, sir.
Have you had an opportunity to view the charges against you?
Like know what it is?
Have you had an opportunity to review the charges against you?
I believe so.
Court did review the affidavit in support of warrantless arrest, did find probable cause. Ms. Perkins, you seeing exception number 16-4-113?
I believe the defendant's currently on bond for a felony out of Weld. I think that's an exception, is it?
I
getting
believe
that
it would
wrong?
only just be warrants,
Okay. Then
unless I'm mistaken. So,
I think our guidelines said something different, but if that's what you go by, that's cool.
well, I can double check. Fails to sufficiently identify himself, refuses to sign the PR, imminent bodily harm, no ties to jurisdiction, previously failed to appear for trial, outstanding warrant. Okay. Any other recommendations on bond?
No, Your Honor.
Okay. Ms. Marchek, any additional record?
Just that per the administrative order, there is no exception. She shall receive a personal recognizance bond under the law.
The court's going to set bond the amount of $500 personal recognizance bond. The court's going to order enhanced pretrial services. Court will authorize MIPS. Remain law abiding, report to pretrial services within 24 hours of your release. Report probation as well. Comply with the mandatory protection order. States you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of actually charged with committing. No contact with the named victim in the affidavit with a 50-yard distance restriction. Next court date will be August 25th, 2025 at 1:30 p.m. in 5D. Anything else from the people or defense?
No.
No, Your Honor.
Thank you.
Thank you.
Deputies, who we have next?
We have Mr. Coolen on the mobile unit, Your Honor.
Okay.
Yes, good afternoon, Your Honor.
Good afternoon. Roland 25M1922. Good afternoon. State your name for the record.
Oh, James Coolin.
Did you watch a video or read a piece of paper advising you of your rights?
I have not, but I have seen before because I have a case pending before you. I have arraignment September 2nd on a similar charge.
Okay. Do you have any questions regarding your rights?
I don't have questions regarding my rights. I did want to say that in relation.
Well, Mr. Coolin, I always advise individuals to speak through their attorneys. Everything is recorded, could be used against you at a later date and time. Purpose of today is to determine bond and bond conditions, not guilt or innocence. With that said, you do have a right to speak on your own behalf, but I'll give you that opportunity after both attorneys have spoken, okay?
Okay.
All right. And have you had an opportunity to view the charges against you?
I believe so, yes.
Okay. Court did review the affidavit and support a warrantless arrest, did find probable cause. We'll start with the people regarding bond and bond conditions.
Thank you. This defendant is currently under pretrial supervision for this exact same offense that occurred in March, where he had an open alcoholic beverage in his car and was charged with a DUI. He was ordered to submit to random UAs by pretrial, so it's concerning that he was still drinking while driving while being on UAs. And that in this case, he had cocaine and 3 bottles of vodka in the car, as well as a rifle. Of note, he was also convicted of prohibited use of a weapon.
That's breakfast. Okay, that's just breakfast.
Been here in Colorado, and was charged with being reckless with a gun in 2019 and another alcohol.
She did it too. That's the second one. Colorado, not Colorado. So she says it, and so does the prosecutor.
Related offense in Kentucky. For that Kentucky case, the defendant has been a fugitive ever since. So the people would request a $500 cash bond, enhanced pretrial supervision.
I agree, Neil. It was a huge deal. So I married my husband, and his whole family is Puerto Rican, and then when I was working at my drywall company, I was in the office. They were Mexicans, and it was a big deal. So if you listen to what's Enrique Iglesias sing, he's from Spain. If you listen to, it's called Religious Experience, but it's in Spanish, so I can't say that in Spanish, but you could hear the lisp, and it was a big deal when my Puerto Rican speaking family, when they heard people th the d, not so there's natural thing the d in like I'm cansada, I'm tired, they th that, but if you th all your d's, if you don't say some of the d's correctly, that's Spain. You're the Spain Spanish, and like they would pick up on it like almost instantly. And it's like a switch. Oh, Spain Spanish, it was a big deal. It was a topic of conversation. When and where and how you th that d, and where you're from if you do it.
And since the defendant was submitting UAs with pretrial services and still was drinking and driving, we would request daily UAs rather than the recommended twice a week, random BAs, and no weapons or firearms. And we would also ask that he be prohibited from leaving the state due to him leaving the state in his Kentucky case.
Thank you. From the defense.
Yes, Judge, we're asking that you adopt what the bond commissioner agrees is an appropriate bond in this case for a $2,250 co-signed personal recognizance bond. We have no objection to the enhanced pretrial supervision. He has minimal criminal history and has been in Colorado for the last 52 years. He is employed here. He has family ties to the state here. And so for those reasons, I think the bond commissioner's recommendation is appropriate.
Being the bond application arguments from the people in the defense court, those notes that you pass score of 2, overall score of 8. Reading the affidavit as well. Court's going to set bond in the amount of $5,000 co-signed PR bond. Court's going to order enhanced pretrial services, no alcohol, no drugs, no marijuana without a valid prescription. Monitored sobriety is directed by pretrial services, random. Well, pretrial, I just want to make sure the random UAs with ETGs, those go back, is it 3 days?
Is that me, Your Honor?
I'm
Pretrial?
not sure, Your Honor. Yes, I'm sorry. I'm not sure,
That's
Your
fine.
Honor.
Okay. I'm fairly certain that those go back a few days. So the court's going to order random UAs with ETG authorized, allow monitor any use throughout the week. Report to pretrial services within 24 hours of your release. No weapons. Obtain permission before leaving the state. Comply with the mandatory protection right of state shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the act or charge of committing. No driving without a valid driver's license or insurance. Next court date will be September 2nd, 2025 at 1:30 p.m. in L1. Anything else to the people or defense?
No.
Nothing from the people.
Thank you. I see Denver on the line. We're going to go ahead and call the Denver matter.
Your Honor, Mr. Coolin had a question. I just have one thing to mention, sir. I understand that there was a firearm in the vehicle, but it's an heirloom. It doesn't even work. I had all my personal belongings in the truck.
Mr. Coolin, you're just incriminating yourself right now, okay? The bond's set. Bond conditions are set. Okay?
Okay.
Ponce 25M550 from Denver. Good afternoon. Could you state your name for the record?
Salvador Ponce.
Did you watch a video or read a piece of paper advising you of your rights?
No.
Okay. So, well, let me, Mr. Ponce, I'll just give you and I'll just let you know why you're in front of the court. You're in front of the court for a failure to appear back in June.
I've been in
this
jail
year.
ever since. I've been in jail since May 10th.
Okay. I do have a representative from the public defender's office here. Would you like an opportunity to speak to her or?
I really don't care, no.
Okay. Well, your bond's been set at $50 cash. You said you were in custody?
I've been in custody since May 10th. I got a PR bond for this case on May 11th, and then the court was May 16th, but I have never been out. I haven't been out. I was in Arapahoe County since May 10th, and then I just got transferred to Denver yesterday.
And Judge, that appears to be accurate.
Okay, so here's what I'm going to do. It looks like this is a petty offense. So I'm going to modify this to a personal recognizance bond. I'm going to make it a $100 personal recognizance bond. I'm going to order that you remain law-abiding. You comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the act or charge of committing. Actually, you know what, Ms. Perkins, before doing that, I should give you an opportunity to make a record if you would like.
No record from the people.
Okay. I guess same for you, Ms. Morchek.
No, nothing further.
Okay. The court's going to order that you refrain from famous footwear at 4352 South College Avenue. Distance restriction of 50 yards. Is it Ponce or Ponce?
Ponce.
Ponce. Do you anticipate being in custody in Denver for a while or?
Yeah, probably another month or so.
Okay. We could, for your next court date, we can do a virtual writ or writ in person. Do you have a preference?
I don't care. For virtual would be fine.
Ms. Perkins, can we prepare a virtual writ August 25th, 2025 at 1:30 p.m. in 5D?
Yes.
Thank you. Anything else from the people or defense?
Nothing
No.
from the people.
Thank you. Deputies, we have next.
Thank you.
Thank you, Ms. Ponce. You can log off. I'm sorry, who's that?
Medina in Station 2.
Did he say Medina?
Did you say Medina or Villa?
Medina, first name
Medina.
Benito.
No,
Medina.
Medina, Medina.
Good afternoon. Could you state your name for the record?
Benito M. Medina Jr.
Did you watch
Right
video?
after the
Read
M.
these?
No, I read the paper.
Do you have any questions regarding your rights?
No, I denied them all as far as on your eligible facility.
Did you have you had an opportunity to review the charges against you?
Have I had the opportunity to read the charges against me?
To review them.
Yeah, basically it said that I was here for.
Well, I don't want to know if you've. I'm just asking if you've reviewed them. Have you been able to see the charges against you?
Yeah, I was able to see them.
Okay. Court did review the affidavit and support a warrantless arrest. If find probable cause, will start the people regarding bond and bond conditions.
The defendant has extensive criminal history out of Texas. Of note, he was convicted of first and second degree robbery in Texas, convicted of assault on a family member with a prior, which is a third degree felony, a DUI resulting in serious bodily injury, a third degree felony, and a felony drug charge as recent as 2024. That was also in Texas. So since the defendant was non-cooperative, we have concerns that he doesn't even live here. So I'm not sure if that's accurate or not, but we would ask for a $500 cash only bond with monitored sobriety and random UAs, as well as prohibition from leaving the state.
From the defense.
Yes, Judge, we're going to ask for a co-signed personal recognizance bond. Mr. Medina has no criminal history here in Colorado. We don't have the CPAT information. And so I think that with no criminal history here, that a co-signed personal recognizance bond would do, both to assure his compliance with pretrial bond conditions, as well as his ability to make his next court date, mitigating the district attorney's concerns, as well as honoring the fact that he has no criminal history in the state of Colorado.
I would like to as well state that there's no proof of evidence of anything because I am here only for a simple.
Mr. Medina.
Sir?
Mr. Medina, we're not here to determine whether you're guilty or innocent today, okay?
Then what is it? Just my bond? But I deny everything to go to jury trial. We are under a grand jury trial right now to the feds too.
Mr. Medina, you're not helping yourself right now, okay?
I don't understand.
Court's gonna go ahead and set bond in the amount of $5,000 personal or co-signed PR bond. Court's gonna order standard pretrial services. Court will authorize MIPS, no alcohol, no drugs, no marijuana, without a valve prescription, monitored sobriety directed by pretrial services. Random BAs, random UAs, no driving without a valid driver's license or insurance. Obtain permission before leaving the state. Remain law-abiding. Report pretrial services within 24 hours of your release. Next court date will be August 21st, 2025 at 1:30 p.m. in L2. Anything else in the people or defense?
Nothing
No.
from the people.
All right, thank you. Deputies, who have next?
We have Alcázar on Station 3, Your Honor.
Good afternoon. Could you state your name for the record?
Gilbert Alcázar.
Did you watch a video or read a piece of paper advising you of your rights?
I read the paper.
Do you have any questions regarding your rights?
No.
Have you had an opportunity to review the charges against you?
Yes.
Court did review the affidavit and support a warrantless arrest. If find probable cause, will start the people regarding bond and bond conditions.
The bond application says this defendant's under probation supervision here in Larimer, but I don't believe he has any open cases here that I can see. And most of his criminal history is from the 80s and 90s. Because of that and a low risk CPAT score, I would believe the bond recommendations are appropriate, and specifically would ask for him to submit to UAs.
From the defense.
We also agree that the bond commissioner's recommendation is appropriate for a co-signed personal recognizance bond. He is on disability. He was a plumber for 12 years in construction prior to that. He's renting a place where he's on the lease in Greeley. He's been in Colorado for 10 years. He's got family, including his brother and sister, nieces and nephews, daughter, granddaughter, all here. So he has significant ties, and that co-signed personal recognizance bond would be appropriate.
So Ms. Perkins or Ms. Morchek, do we know if he's on probation? Ms. Bergen?
He
do you know?
is.
Apologies, was that a
Yes,
question?
probation? Okay.
Yes.
I just want to make sure before I order it. So it seems like he is. Okay.
Yeah, I couldn't figure out why.
Yeah, that's fine. I just wanted to make sure before ordering it. Of course, this set bonding amount of $5,000 co-signed PR bond. Of course, in order standard pretrial services, no alcohol, no drugs, no marijuana, without a valve prescription, monitored sobriety directed by pretrial services. Random UAs remain law abiding. Report to probation pretrial services within 24 hours of your release. Comply with mandatory protection order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to, victim, and actual charge with committing. Next court date will be August 25th, 2025 at 8:30 a.m. in 3B.
Okay, let's stop with Sergio and go to this guy. This is the guy. He could have been the guy, but he wouldn't unmute, so I'd left him.
I'm sorry, the miss appointments. I know I had emailed you.
Kelly,
I
thank
did. You said
you,
it wasn't
thank
proper
you.
to be responded on email at the time, but I said that I only had one email showing that I missed a meeting with you. Does that ring a bell? That you received an email from me during this process?
Yes, I did receive emails from you as you didn't had struggles with phones, but according to my records, I do have that handful of missed appointments.
Okay, thank you. And you said earlier that you called me in the beginning, but you just related that I didn't have a phone number. So the only communication I had was email. And if I don't have a communication on that, I just don't know how I was supposed to know that I missed an appointment. If you tried to call, I don't have a phone number.
Okay, so you need to ask a question
Is that-
directly of the witness.
Oh, I'm sorry.
This is something maybe that you could argue to the court.
My bad.
That's all right. Next question for this witness.
So then the third topic was the hot UAs and then the missed appointment. And then can the court remind me of the third thing spoken of by the
Payment
DA?
plan, failure to set up a
The payment plan. Thank you. Have I been making a payment every month?
Yes.
And I told you that I just wasn't willing to sign up with the creditor, correct?
Yes.
Okay, but I have been making payments and I'm trying to pay it off. I mean, I'm sorry, but you're just acknowledging I have been making payments.
Yes.
Okay, on both accounts okay, thank you. And then I think that's the only thing that was covered. So thank you for your,
Okay, thank you. Any redirect for the people? Okay, thank you, Ms. Lincoln. You may step down. Mr. Adams, you have a right to testify. You don't have to if you don't wish to. If you choose to testify, you can be cross-examined by the people. Would you like to testify?
yes.
Okay, you can
So
stay there. Just raise your right hand. Do you swear and affirm under penalty of perjury the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. What would you like me to know? And please speak slower so I can take
Okay.
notes.
Okay.
Go ahead.
That I am supposed to be consuming alcohol according to this prescription I'm taking
Mhm.
2 to 3 times a day. It's 8% alcohol.
All right, nurses. Or if there's a doctor in here, is that complete BS? I need to know if that's BS. He says he is supposed to be consuming alcohol 2 to 3 times a day because his doctor prescribed it. Now, I don't know. He doesn't really explain if it's like a medicine that has alcohol in it. But he doesn't explain the alcohol. If he says it's just a tiny bit. But I think it's bull. I think it's a bunch of bull.
It's 5 milliliters times 2. So I'm supposed to take 10 milliliters 3 times a day. And I did feel a little intimidated. So I tried to work with the system, but I am supposed to take it for my best health. And the other thing is I was always under the impression of your ruling that I was okay to be consuming alcohol, but not to excess. And I have literally not ever gone excess compared to when I did drink full time. Like, I did everything I could to not go excess. But also, I would like you to know that I've completed every court order that you and the other judge required. And even if I did have a hot UA, it didn't impair anything. I don't have a problem with alcohol. I don't really find it that appealing. But when I come into places like this, I find a need that there's a lot of energy and I want to drink, but I don't on a normal basis want to drink alcohol. So I don't like, and I went through the whole 39 weeks of DBT, and I went through 11 weeks of CBT, and you know, I really realized that alcohol it's a poison, and it's not something I want to consume in excess. It's imbibing is bad for you, and I know that it's harmful to your body and your brain on long term. And I'm not trying to abuse the system, but I just want the court to know that I really was following your court orders, and I was just utilizing my prescription. And it says literally on the thing that I can go as needed. And nobody here knows about my disease, but I do need it. So it's just, it's something you swallow as well. They had a misinterpretation that it was a mouthwash, and it's not. It's a syrup and you drink it.
Okay.
So that's all I wanted to say.
All right, thank you. Cross-examination of this witness?
You complied with everything the judge ordered, correct?
Correct.
So he said it's a syrup. So it's probably cough medicine, just like you said.
You were,
I'm sorry?
the judge, you to take urine testing when ordered by probation, correct?
That's the one thing I didn't bring up. Yes, that is correct.
That's a yes.
Yes.
On August 22nd, you did not take a urine test when you're required to, correct?
I did show up and I signed the thing, but they didn't care about it.
Did you take a urine test?
I didn't have the money and I told Perdition, so I could not take it. Correct.
No.
Correct. I couldn't take it.
And on 24, you were asked to take a urine test, correct?
I don't know about the date off the top of my head, but I know the only time I missed it is I didn't have the funds.
But you did not take it.
Well, I mean, how can you take it? They won't.
Nan, what if how much antihistamine would I need? Like, okay, how do I get the doctor to prescribe me a 5th as a prescription for whatever antihistamine? I'm sure that's for allergies, right? How bad do I have to present allergies for him to prescribe me a 5th of vodka every day? That's what I need to know, Nan.
Won't let you. So without money. So no, I didn't take it. Correct.
And as part of the judge order was for you to enter in a payment plan with the court for your court costs, correct?
The payment plan
Was
that
that
I've been
part
paying
of-
every month?
As a condition of supervision in the matter, the court case you're in, it was stated that you shall pay the following amount, so the $619.08, or enter into a payment plan.
Yeah.
Yeah.
I've been paying every month. Correct.
You have not entered into a payment plan.
Why do I need to do that if I'm paying? I mean, there's no need.
Did you enter into a payment plan? Yes or no?
Yeah, I told probation I'm gonna pay every month, and I have been.
Did you enter into a formal payment plan? Yes or no?
Is that formal? No, it's not. According to your interpretation, it's not, but according to mine, it is.
No further questions, Your Honor.
All right, thank you. All right, this, I'll hear argument for the people.
Six occasions, failed to apply, test on 3 separate occasions. three separate occasions. This, we would be asking, for the court of probation and thus it's.
All right, thank you, Mr. Adams. Anything further you would like to say?
Yes, I just
You had
wanted,
mentioned that you had done this DBT and the CBT. Did you complete the education and treatment on the DWAI case?
yeah, I sure did. It's all the
Did you do the
certificate.
community service?
Yeah, community service is done. Everything's done. You asked me to see a evaluation. I did everything that the court asked. It's all completed 100%.
Okay. Anything else you want me to know or consider in terms of?
Yeah, I just wanted to point out that those technical mistakes were in 2024. And I had never been in the system, so I was just learning. I didn't have a phone, and I realized how difficult it is to call and such without a phone. You know, you have to call in every day. So I haven't made that mistake since. I've learned from the mistakes. The fact that they're asking for jail time for someone who's completed everything the court asks, I just find it's kind of challenging. But I just wanted to let you know I haven't made any mistakes since 2024 on the technical side. And the hot UAs were all because I thought I had the ability to use my prescription. I thought I had the ability to not go excessive on alcohol. You know, that's all I have to say.
All right, thank you. The court heard testimony today from Ms. Lincoln that Mr. Adams, while on probation, he did test positive for alcohol on May 8th, June 28th, July 9th, August 12th, November 12th, January 17th, and March 13th. Mr. Adams said that that was a result of a prescription that was prescribed by his doctor. It does contain alcohol, and he informed probation of that fact. Mr. Adams is correct. The court prohibited alcohol in excess in the 22M2102 case, the harassment case. In the DWAI case, I was not the sentencing judge. That was Judge McGid. But the court did prohibit alcohol consumption on that case. So it can be a little confusing, but alcohol consumption was prohibited in the DWAI case. The court heard that he missed test on August 22nd, October 17th, and October 24th. And they failed to report to probation on July 16th, September 26th, and November 16th. Mr. Adams testified that he has been paying monthly, but he did not enter into a payment plan. He referenced something with a credit agency. So the court isn't familiar with that necessarily, but there was testimony that he has been paying monthly, but he didn't sign with the, I guess, agency that was willing, that works with probation so that those fees could be paid. And then I guess Mr. Adams would just have that amount of debt to a collection agency. Mr. Adams testified that, again, his alcohol use is due to this prescription, that he's is supposed to take it. He has not drank in excess. He's not interested in drinking. And he did complete 39 weeks of DBT, 11 weeks of CBT. He was trying to follow the court orders. He did miss UAs because he wasn't able to afford them. He didn't have the funds. And he testified that fully complying with probation was difficult without a phone. A lot of this happened in 2024, and he's learned from his mistakes. And he did everything that was required of him in both cases on probation, except for the positive UAs for alcohol, as well as the missed UAs and the missed appointments. He did cross-examine the probation officer and say that he emailed after he missed a meeting with her. And then she said she did receive emails from him. So the court noting the standard of proof is preponderance of the evidence and more likely than not, does sustain the complaint on the allegations that he violated probation by missing appointments, missed tests, hot urinalysis tests for alcohol, and failure to set up a formal payment plan while on probation. So I am going to find that he's in violation of probation. I guess the question is, what is the appropriate sanction for somebody who's done a lot of the recommended treatment, required treatment, and other conditions on probation? Ms. Lincoln, if I could hear from you regarding, just to confirm that Mr. Adams completed the community service, MAD victim impact panel, education and treatment that was recommended.
Yes, he did complete both of those, the MAD panel and the community service. I do have verifications of those. I don't have them with me
That's
now,
okay.
but they are in there. And then he did complete the DBT and the CBT classes, like he said, as well.
Okay. Does probation have a recommendation in terms of sentencing? Doesn't sound like Mr. Adams wants to be back on probation. I'll hear from him in a moment, but.
Right, probation would not be a recommendation at this time.
Okay. Thank you. Appreciate that. Mr. Mindtree, for the people, what are the people recommending?
I've been reviewing these cases. They're obviously fairly old in the sense that the offenses are old themselves, but I believe with the 2022 case, the 22M 2202, the disposition was in January of 24. Your Honor, I guess the issue that the people have at this time is after hearing Mr. Adams' testimony today, we are encouraged that a lot of it has been completed. I think both cases, though, stem from alcohol use, substance use of some sort. And for what I haven't heard today is a real reason on why he's testing positive. I've heard Mr. Adams' reason. We've all heard Mr. Adams' reason. We've also heard Mr. Adams say that he thought that he could drink not to excess. So something's telling me that there was some drinking going on along with this. And it's not clear to me that he's going to be safe out in the community after this. I don't know if that means a short probation stint added on to at least one of the cases, maybe the 23M case, 23T 6184, or a short jail sanction. But I do have slight concerns with his substance use in the future. Thank you.
All right, thank you, Mr. Adams. What would you like me to know or consider?
Well,
I guess I just want to know, are you working?
yeah,
Where do you work?
I work for myself.
Okay. And do you have a place to live?
Yeah,
Okay.
I mean, pretty much, yeah.
Okay.
I mean, in 20 months of probation, I haven't violated one thing.
Okay. No, I think you've done a lot on probation, and I do take that into consideration. These violations mean that you didn't complete it successfully. That's why I sustained the complaint. I'm inclined to revoke and terminate unsuccessful with a sanction. I'm not going to put you back on probation. I'm not going to put you in jail. I think that you've substantially complied with probation, but there should be a sanction. What I'm thinking about is, and that's why I asked if you have a place to live, is some in-home detention. You work from home?
I do. I mean, I work pretty much from anywhere, but
Okay. And I think I'm going to do 30
Liar.
days of electronic alcohol monitoring. Well, it could interfere with the prescription. I'm going to do 30 days of in-home detention. He will have to pay for that. You have to set up a payment plan for that. That'll be concurrent with each other. And you're to complete the in-home detention sentence by October 14th at 8 a.m. or come to court we'll vacate it once we get confirmation from intervention that you completed the in-home detention sentence. So, once you do that, that'll be satisfying to the court. You'll fulfill the sanction. You won't be on probation any longer. This hopefully doesn't take away from the great deal of things that you did do substantively on probation, and I appreciate it. Anything further from the people?
No, Your Honor. Thank you.
Anything further from you, Mr. Adams?
Are you
We're
just
gonna
saying?
give you the paperwork. You'll contact intervention today. They will arrange your in-home detention sentence. You need to complete it by October 14th at 8 a.m., but you'll talk to them.
I heard you. I
Okay.
just was curious, are you putting me on an ankle monitor?
Yeah, it's ankle monitor.
So I just can't
I
leave
heard
the
you,
presence?
but what did you
You
Or-
say?
can go to work, you can go to doctor's appointments, you can go to therapies,
You
but
got
you
this
can't,
ability.
it's house arrest for 30 days. So it's restrictive. There is some personal time that you'll get, but that's, it's intentionally restrictive because it's an alternative to jail. Okay? All right. Thank you, Mr. Adams. We'll give you that sentencing paperwork
Thank you.
in just a minute. And thank you, Ms. Lincoln and Mr. Mindtree.
All right, we're going to hop over to Maricopa to end this day.
Que es un delito mayor de clase 4.
I have found probable cause to support that allegation and appointed a lawyer to defend you.
He encontrado que existe motivo fundado para el sustento de esa acusación y he nombrado un abogado
We get to see the judge today.
para que lo represente.
Your next court hearings will be a status conference August 28th and a preliminary hearing September 2nd, both at 8:30 downtown.
Sus siguientes audiencias serán una conferencia de estatus o de estado del caso el 28 de agosto y una audiencia preliminar el 2 de septiembre, ambos audiencias a las 8:30 de la mañana en el Tribunal del Centro de la ciudad, downtown.
I am inclined to release you on your own recognizance on this allegation.
Estoy considerando dejarlo en libertad bajo su propio reconocimiento sobre estas acusaciones.
That means you would be released from custody. You would then be responsible for getting yourself to both of your next court hearings.
Esto significa que usted saldría de custodia y usted sería responsable de comparecer en ambas audiencias.
Upon release, you would also be ordered not to possess any drugs without a valid prescription.
Una vez que salga en libertad, también se le ordenaría que no tenga posesión de ninguna droga a menos que tenga una receta médica válida.
Do you understand those conditions and agree that you'll abide by them if released?
¿Entiende usted esas condiciones y está de acuerdo en acatar esas condiciones si es que se le deja en libertad?
Sí.
Yes.
Okay, thank you very much, sir. You can step back and get your paperwork.
Muchas gracias. Puede pasar y que le den los documentos.
Mr. Interpreter, before you disconnect, would you please make a quick inquiry of the gallery to see if there's anybody else that might require your assistance?
Yes, Your Honor, my pleasure. ¿Alguna otra persona necesita los servicios de un intérprete de español? ¿Alguna persona necesita los servicios de un intérprete de español?
Okay, I am told nobody else has spoken up. Thank you very much for your assistance and for joining us. You are free to disconnect if you wish to.
Thank you, Your Honor, my pleasure. Bye-bye.
Okay, bye-bye. Keep that note because we'll have to deal with it. We don't need to do it right now. Keep it open for now. Okay, next, can I please have Vanessa Figueroa into the courtroom behind the gray podium? Santiago Stopson, if you would have a seat in this first blue chair right inside the door. Iran Beltran Guerrero, if you'd please have a seat in the second chair. Can I have your name and date of birth?
Vanessa Figueroa, 4/10/1999.
Thank you very much, Ms. Figueroa. You are here on two different matters. The first matter that you're here on is a bench warrant issued by the Superior Court when you failed to appear at a not guilty arraignment hearing. The allegations in that case are felony drug allegations. You already have a lawyer in that case. That lawyer will continue to represent you. Your next hearing in that existing case will be a new arraignment hearing August 20th. It'll be at 8:30 in the Superior Court downtown. On that warrant, you have a $500 secured appearance bond. The second matter that you're here on is a grand jury warrant. In that case, a state grand jury was convened and found probable cause to return an indictment against you. The counts of that grand jury indictment are one count of taking the identity of another, a class 4 felony, one count of shoplifting, a class 1 misdemeanor, and one count of obstruction, a class 2 misdemeanor. All of those offenses, according to the grand jury warrant, are alleged to have been committed September 8th of 2024. In that grand jury case, I've appointed a lawyer to represent you. Your next court hearing in the grand jury case will be the same date and time as your hearing in your existing case. So August 20th at 8:30, one hearing date and time, 2 different cases on that calendar. On the grand jury matter, you are not eligible for release on bond. That means you will stay in custody at least until your hearing on August 20th. Because you're not eligible for release on the grand jury warrant, you should not try to post the bond on that other warrant because you wouldn't be eligible for release even if you posted it. Do you understand that information? Okay, thank you very much. You can step back and get your paperwork. Santiago Sopson, if you'd please work your way into the courtroom. Cordell Peets Noble, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Santiago Sopson, 11/21/2006.
Thank you, Mr. Sopson. You are here on an allegation of a new charge. That allegation is one count of unlawful flight from a law enforcement vehicle. It is a class 5 felony. I did find probable cause to support that allegation, and I appointed a lawyer to defend you. Your next court hearings will be a status conference August 19th and then a preliminary hearing August 21st. They will both be at 8:30 in the Superior Court downtown. On those allegations, on that allegation, you have a $5,000 secured appearance bond. If you post that and you're released from custody, you cannot have contact with any alleged co-defendants, and you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes, ma'am.
Okay, thank you, Mr. Sopson. You can step.
I just have one question.
Sure, go ahead.
So that means I will not be released today?
It means you will not be released today unless you post that bond. Okay. All right, thank you, sir. You can step back and get your paperwork. Iran Beltran Guerrero, if you would please work your way into the courtroom. Shauna Mahan, if you'd work your way to the second chair. Can I have your name and date of birth, please, sir?
Iran Beltran Guerrero, June 5th, 1985.
Thank you, Mr. Beltran Guerrero. You are here on an allegation of a new charge. The allegation against you is one count of burglary. It is a class 4 felony. I have found probable cause to support that allegation, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference August 19th, and then you will have a preliminary hearing the 21st. They will both be at 8:30 in the Superior Court downtown. On that allegation, you have a $5,000 secured appearance bond. If you post that and you're released from custody, you cannot return to the scene where the alleged burglary took place. You cannot have contact with any alleged co-defendants or witnesses of that allegation, if there are any. And you are also prohibited from possessing any drugs without a valid prescription if you're released. Do you understand those conditions?
Yes, ma'am.
All right. Thank you very much, sir. You can step back and get your paperwork. Cordell Peets Noble, if you would please work your way into the courtroom. Brittany Moore, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Cordell Peets Noble, January 27, 1998.
Thank you very much, sir. You are here on 2 different matters. The first one is a warrant issued by the Central Penal Justice Court on a misdemeanor case involving trespassing and disorderly conduct allegations. You're entitled to a lawyer in that matter at a minimum for purposes of release conditions. That lawyer will be appointed by the next judge you see at your next hearing. Your next hearing on that misdemeanor warrant will be an arraignment hearing August 18th at 8:30 in the morning in the Central Penal Justice Court. On that warrant, you have a $1,500 secured appearance bond. The second matter that you're here on, I'm sorry, that's the only matter you're here on. That's all you got. So a $1,500 secured appearance bond on that misdemeanor warrant. If you post that and you get out of custody, you will have to get yourself to the Central Penal Justice Court August 18th at 8:30. If there are any victims or witnesses of those underlying disorderly conduct allegations, you can't have contact with them at least until your next hearing on the 18th. Do you understand that?
Yes.
All right. Thank you, sir. Shauna Mahan, if you would work your way into the courtroom, please. Jesus Chavez, if you'd work your way to the second chair. Can I have your name and date of birth, please?
Shauna Mahan, 7/24/87.
Thank you very much, Ms. Mahan. You are here on 5 different matters. The first matter you're here on is allegations of new charges. Those allegations are 1 count of narcotic drug possession, 1 count of dangerous drug possession, they're both class 4 felonies, and 1 count of drug paraphernalia possession, which is a class 6 felony. I did find probable cause to support those new allegations. The other 4 matters you're here on are all allegations that those new charges violated term 1 of your probation in each of those 4 cases. I have appointed a lawyer to represent you in all 5 of these cases. Your next court hearings on the new case will be a status conference on the 19th and then a preliminary hearing the 21st. Your next hearing on the 4 probation matters will be a revocation arraignment hearing on the 20th. So you'll have court August 19th, 20th, and 21st, all at 8:30 in the morning, all in the Superior Court downtown. On all of these cases total, you have a $2,000 secured appearance bond. It is $1,500 on the probation matters, so $500, $500, $250, $250, $1,500 on the 4 probation cases, $500 on the new case. So your total bond is $2,000. It's all secured appearance. If you post that and you are released, in addition to getting to all of your next court hearings, you are ordered not to possess any weapons or any drugs without a valid prescription. Do you understand all of those conditions?
Yes.
Okay, thank you, Ms. Mahan. You can step back and get your paperwork. Brittany Moore, if you would please work your way into the courtroom. Vaudrey Gates, if you'd work your way to the second chair, please. Can I have your name and date of birth?
Brittany Moore, October 27, 93.
Thank you very much, Ms. Moore. You are here on 2 probation violation warrants. In both cases, petitions to revoke your probation allege that you have violated terms 3 and 5. I've appointed a lawyer for you in both cases. Your next court hearing will be a revocation arraignment hearing August 20th. It'll be at 8:30 in the Superior Court downtown. On each of those 2 warrants, you have a $100 secured appearance bond. That means your total bond will be $200. It is all secured appearance. If you post that and you are released, you cannot possess any drugs without a valid prescription once you're out. Do you understand those conditions? Okay, thank you, Ms. Moore. You can step back and get your paperwork. Jesus Chavez, if you would please work your way into the courtroom. Ryan Zamora, if you'd work your way to the second chair. Can I have your name and date of birth, please, sir?
Jesus Chavez, 09-1595.
Thank you, Mr. Chavez. You are here on a probation violation warrant. A petition to revoke your probation alleges that you have violated terms 3 and 5. I've appointed a lawyer to defend you. Your next court hearing will be a probation revocation arraignment hearing. It'll be August 20th at 8:30 in the Superior Court downtown. On that warrant, you have a $100 secured appearance bond. If you post that and you are released, you cannot possess any weapons or any drugs without a valid prescription once you're out of custody. Do you understand those conditions?
Yeah.
Okay, thank you, sir. You can step back and get your paperwork. Vaudrey Gates, if you would please work your way into the courtroom. Summer Al-Fayez, if you'd work your way to the second chair. Can I please have your name and date of birth?
Vaudrey Christian Gates, and then 10-4-1998.
Thank you, Mr. Gates. You are here on 2 probation violation warrants. In both cases, petitions to revoke your probation allege that you have violated term 3. I have appointed a lawyer to represent you in both of those matters. Your next hearing will be a revocation arraignment August 20th. It'll be at 8:30 in the probation court downtown. On each of those 2 warrants, you have a $100 secured appearance bond. So your total bond is $200. It is all secured appearance. If you post that and you are released, you cannot possess any weapons or any drugs without a valid prescription.
Yes.
Do you understand those conditions?
So I can post that like right now and then get out?
You could post that, yes, right.
Okay.
I don't know if it'll happen like right this instant, but yes,
I'm sorry.
you could post that bond. As soon as that bond is posted, you'll go to the release process.
Yes.
That could sometimes take a couple hours. But yes, as soon as you post that bond, you are release eligible on these 2 warrants.
Yes, ma'am.
Any other questions?
No, ma'am.
All right. Thank you, Mr. Gates. You can step back and get your paperwork. Ryan Zamora, if you would please work your way into the courtroom. Jesse Hasse, if you'd work your way to the second chair. Can I have your name and date of birth, please?
Ryan Zamora, 8/19/1995.
Thank you, Ms. Zamora. You are here on a probation violation warrant. A petition to revoke your probation alleges that you have violated terms 3 and 5. I have appointed a lawyer to defend you. Your next court hearing will be a revocation arraignment hearing. It will be August 20th at 8:30. It'll be in the Superior Court downtown, and you have a $100 bond on that warrant. If you post that bond and you are released, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions? All right, thank you very much. Summer Al-Fayez, if you would please work your way into the courtroom. Michael Smith, if you please work your way to the second chair.
Hi, Your Honor.
Hi, can I have your name and date of birth, please?
Summer Alvarez, 12/6/84.
Thank you very much. You are here on an arrest warrant that was issued after a direct complaint was filed. A direct complaint is a written document that alleges new allegations against you. The allegations in that direct complaint are 1 count of narcotic drug possession, 1 count of dangerous drug possession. They're both class 4 felonies, and 1 count of drug paraphernalia possession, which is a class 6 felony. The direct complaint alleges that those offenses were all committed May 30th of 2024. I have appointed a lawyer to represent you in that case. Your next court hearings will be a status conference August 28th and then a preliminary hearing September 2nd. They'll both be at 8:30 in the Superior Court downtown.
Okay.
On that warrant, I am inclined to release you on your own recognizance. That would mean you would get out of custody. You would not be required to post a bond.
Okay.
Upon release, you would be responsible for getting yourself to both of those next court hearings. You would also be ordered upon release not to possess any drugs without a valid prescription. Do you understand those conditions, Ms. Al-Fayez? Do you agree that you'll abide by them if released without a bond?
I agree, and I will abide by them.
Okay, very good. Thank you very much. Then you can step back and get your paperwork. Jesse Hasse, if you would please work your way into the courtroom. Can I have your name and date of birth, please, sir?
My name is Jesse Matthew Jose Jr., and my date of birth is April 10, 2003.
Okay, thank you very much. I apologize for mispronouncing it. It's pronounced Jose.
Yeah.
Okay, thank you, Mr. Jose. You are here on allegations of new charges. The allegations against you are 1 count of assault and 1 count of disorderly conduct. They are both class 1 misdemeanors. I did find probable cause to support those allegations. Because they are misdemeanor offenses, you are not entitled to a court-appointed lawyer. That means if you want to have a lawyer defend you against those allegations, you will have to hire a lawyer at your own expense. Your next court hearing on these allegations will be an arraignment hearing September 2nd. It will be at 9 o'clock in the morning in the Peoria Municipal Court. I am inclined to release you on your own recognizance on these allegations. That means you would be released from custody. Upon release, you would be responsible for getting yourself to that hearing September 2nd. You would also be ordered not to return to the scene where the underlying alleged events took place. You could not have any contact with the alleged victim or victims of the underlying allegations. You would be prohibited from possessing any weapons, drugs without a valid prescription, or alcohol upon release. And if any orders of protection have been or are later served upon you, you would be required to strictly comply with the terms of those orders. Do you understand those conditions, Mr. Jose, and do you agree that you'll abide by them if released without a bond?
I agree, and I understand the conditions.
Okay, thank you very much, sir. Then you can step back and get your paperwork.
Thank you, miss.
Mr. Smith, if you'll give us just 1 quick second, we will get to you here in just 1 minute.
I can make a minute go faster.
Allegations of new charges. Those allegations are 2 counts of driving under the influence, both class 1 misdemeanors. I did find probable cause to support those allegations, and I've determined he's entitled to a court-appointed lawyer. That lawyer will be appointed at his next court hearing. That'll be an arraignment hearing August 28th at 1 o'clock in the afternoon in the North Mesa Justice Court, and I do intend to release him on his own recognizance. Number 26 on the calendar, Sabrina Dottie, date of birth 7/6/96, is not in the courtroom because she was unable to function in general population and posed a potential risk to herself or others. She is here on 2 different warrants, both issued by the Surprise Municipal Court, both in misdemeanor drug paraphernalia possession cases. Because they are both misdemeanor cases, she's not entitled to a court-appointed lawyer. Her next court hearing in both of these matters will be an arraignment September 9th at 1:30 in the afternoon in the Surprise Municipal Court, and I do intend to release her on her own recognizance on both of these warrants. If anything changes after I visit either of these individual cell sites, the court's final orders regarding release will be reflected in their written release orders. Okay, thank you very much for your patience, Mr. Smith. If you would work your way into the courtroom. Can I please have your name and date of birth?
Michael Smith, 9584.
Thank you very much, Mr. Smith. You are here on allegations of new charges. Oh, I'm sorry. I think that the lawyer for the state intends to appear on this case. Appearance of counsel for the state.
Thank you, Your Honor. Dawn Sauer on behalf of the state.
Thank you, Ms. Sauer. I apologize for skipping you. Okay, Mr. Smith, you are here on allegations of new charges. Those allegations are 1 count of molestation of a child and 1 count of sexual conduct with a minor. They are both class 2. I address the, you have the community.
All right, we did it. We got to the end of that. We're not going to listen to that last case. Screw him. I hope you guys have a great day. A lot of you will automatically go to OJ. A lot of you will automatically go somewhere else. Thank you so much for coming out today, guys. I appreciate it. Hope you guys have a great day. Bye.